is the types of contracts. So there are various types of contracts, as you've already heard about it. So looking into the contents as to what are the types of the contract, normally the specific terms and conditions of each contract is unique, and that is done so to cater for a specific need of the parties, which is drafted by the people who are getting into the contract. Yet even after taking into consideration the differences and the similarities that are found in the contracts, there can be certain types of classification that can be done on the basis of how they are formed, whether they are valid, the basis and the nature of the execution, and other legal requirements, etc. So the categories of contracts mentioned in this particular article might overlap in the sense that most contracts can be of many types. So some of the examples are the verbal contracts, the valid contract, the unilateral contract, and the categories mentioned are thus distinct and are equally important when you are getting into contracts. So the types of contracts which are formed on the basis of the contract itself is the verbal contracts. So verbal or oral contracts are those which are formed by oral communication. From the time immemorial, contracts have been made orally itself. Earlier, there was no law, there was no proper drafting of the contracts or agreements, so it was all done orally. But because verbal contracts are very difficult to prove in the courts, these contracts are thus generally not made anymore. So, having said that, the verbal contracts are valid contracts and enforceable by the law, provided that they fulfill the conditions of valid contracts as given in section 10 of the Indian Contract Act 1872. Moving on, in the case of Nayak Builders and Investors Private Limited versus Vinod Kumar Alga in 1991, the Delhi High Court observed that an oral agreement might be a legitimate and enforceable contract. As a result, a contract does not have to be in writing in the literal sense unless it is required by the law itself, or the parties deliberately intending to reduce the terms of the agreement to writing. Normally, everyone does that so that there is a precise idea for each party to what to do and what not to do. And tomorrow, parties may change their approach towards the contract, or they may change the rules and regulation of the agreement. So, to avoid such ambiguity and confusion and taking a different turn, what they do is they normally put it down in writing so that both of them have a copy, a hard copy, and prescribed terms and conditions as to what has to be done and what should not be done in a contract. So the validity of the verbal offers and acceptance comes indirectly from section 2 of the Indian Contract Act. Okay. So according to section 2A, what does it say? It says a person is said to make an offer when they signify to another their willingness to do or not to do something. When does a contract or an agreement come to existence? It only comes to an existence when one person makes an offer as to this should be done by you, and that same is been accepted by the other person. Need not be this should be done by you. There can also be this should not be done by you condition also. These terms and conditions, when they are precisely mentioned in a piece of paper, written, printed, it becomes a written contract. Okay. When it is not in a written form or there is no copy of the contract, it becomes just a mere oral contract. Okay. Further, section 2B states that the acceptance is given by signifying assent to the offerer. So, how do you accept getting into a contract? To be in an agreement, you have to signify your assent, your approval to follow the terms and conditions made by the offerer. Okay. The term signify plays a very important role in showing that offers and acceptance can be given without actually writing it down. So you need not exactly write it down in an oral contract. It can be oral, mouth to mouth. Okay. Offer is made by one person without any writing, just orally, and the other person also accepts the offer without any signification of writing, but just orally accepting the offer becomes the oral contracts. So now let's get into what is the written contracts. Contracts that are formed in the written and tangible form are contracts called as written contracts. These are the most prevalent types of the contracts at present, because no one wants to take the risk of ambiguity and the offerer or the offeree deviating from the original terms and conditions. So to stop such confusion and to lessen the ambiguity in the agreement or the contracts, what they are doing is they are putting it in writing, so that when there's a hard copy of the agreement or the rules and regulations that they have accepted to, the offer and the offeree accepting the acceptance of the offer, that is the evidence of what actually has happened. So when they fulfill the conditions of section 10, they are called the valid contracts. Next is the express contracts. Contracts are made of proposals or offers and acceptance of such proposals or acceptances. So proposals and the acceptance of the same can be expressed or implied. When you are expressing something precisely, writing it down as a point in a particular piece of contract or an agreement, it is called expressed right or an expressed contract. Okay, but when you are not expressing it, but the other person, it is implied to the other person to follow certain things, it is implied contract. Not everything in law is expressed. Everything cannot be put in words and sentences. So there are certain things that has to be followed without putting it in words in the piece of agreement. Okay. So according to section 9 of the Indian Contract Act, a proposal when made in words is an express offer. Thus, an express contract is made in words either verbally or through written form. So, these express contracts are very swift in nature. So, they are either made verbally or through a written form, but they are quite quick. Okay. So, for example, A asks B whether he would like to sell his house for an X amount. B agrees to the same by saying yes. This is an example of an express contract. Thus, in an express contract, the terms of the contracts are very clearly expressed. Okay. Next, implied contracts. What are implied contracts? Section 9 also recognizes implied contracts. It states that an offer or acceptance made through anything else other than words is an implied offer or acceptance, because in an implied contract it is based on the actions, gestures of the involved parties. As I already mentioned, everything cannot be put in words sometimes. So there is an implication, an implied meaning that if a person is getting into a contract, it means that there is certain rules and conditions that he has to follow, and there are certain things, obligations that without fail he has to fulfill. So they are called the implied contracts. For example, in an auction, raising the numbered paddle by the customer is an implied offer. So when people attend an auction, they raise their hand holding the numbered paddle that is given to them. For example, if a person A is given number 1, B is given 22, and if he has to quote a price in the auction, he has to hold up his paddle that is numbered with a particular number. So that is an implied contract that you are getting into the auctioneer when you are attending an auction. So without that, you cannot claim that I need not put up my number paddle, but I have the right to speak. No, the right to speak only comes when you put up the number paddle, okay, by the customer. So it is an implied offer, and the final bang of the gavel, the hammer type material, which is used by the auctioneer at the end of the auction, signifies the product is sold. Only when the product is sold, they hit the gavel or the hammer like material, the instrument on the table, signifying that the product is sold. So that is an implied contract. So even when you are attending as an auctioneer or an auctionee, you have certain rules, regulations and duties that you have to follow, and those are not entered into through contract, but it is implied. When you attend an auction place, you have to hold the number paddle and signify your interest in betting for that particular product. If it is sold to you or if it is sold to anyone, then after saying sold, they hit a hammer like instrument or a gavel, which is called, on the table, signifying sold. So that is an implied. No one tells you that when the hammer is hit, it means that there's no written form of it. But when you attend a particular this auction, it is so mentioned and it is known that you are going to follow these rules. So this is thus an example of an implied contract. A warranty on a product is another example of an implied contract. When you go and buy an iron box, there's warranty given to it for a year or 2 years or 10 years, whatever the time duration is. But it is a implied contract. You're not getting into a written contract with the manufacturer himself. But when he says 2 years warranty, it means you can claim the warranty at any point of time if the product goes wrong or whatever the conditions that he has prescribed to claim the warranty, and you can take the benefit that is given by the manufacturer to the buyer. You literally don't go and sign the contract there with the manufacturer, but the warranty itself signifies that there's a contract between you, the buyer, and the manufacturer. So that is called a implied contract. Okay. So when you buy a product, you get a warranty that it will work as expected and advertised. The contract is implied since it came into force when someone made a significant or specific action like purchasing a goods. When does this implied contract come into place, or when does it get activated? Only on purchasing a particular goods. Before that, does it activate the warranty that has been put on that particular product? No, because you have to buy the product. Only then that warranty will apply to you, even if it is not written down anywhere. Okay. So just like express contracts, there must be a meeting of the minds of both parties. Just keep one thing in mind, guys, that between in any contracts or between any parties, when they're getting into an agreement, there must be meeting of minds. If one party is thinking something else and the other party is thinking something else, there cannot be a contract, because they cannot work consensually towards a common goal or an accepted result. They can't get. So they have to get the accepted result, predicted result. They must have the meeting of minds of both the parties. It is much more difficult to ascertain the meeting of minds in a contract when terms and conditions of the same are not explicitly mentioned. So, courts have often used or often refused to recognize implied contracts wherein meeting of minds cannot be ascertained with clarity. So what happens in implied meaning, not every time the meeting of minds happens between two parties, because the seller doesn't know, the manufacturer doesn't know who is buying the product, and the person buying the product doesn't know what the manufacturer is thinking. So there is no meeting of minds in the implied contract. That's why court doesn't it refuses to recognize implied contracts, because there is no proper meeting of minds of two parties. Okay. So in case of Haridas Ranchoddas versus Mercantile Bank of India Limited 1919, when the customer of the bank did not object to the charge of a compound rate of interest in accordance with the usual course of business, he was held to have impliedly contracted to pay the new compound interest. So you need not expressly tell that you accept it, but mere refusal to deny a particular thing also means that you are accepting that particular thing. So silence or keeping quiet or not protesting against something or not speaking against something is considered to be accepting as it is. Okay. So that is what happened in this particular case. So next comes the quasi contracts. Sometimes rights and obligations might arise not by contracts that the involved parties have assented to, but rather by law. So these create legal relationships that resemble contracts and are called quasi contracts. With the word quasi, it means seemingly, which means semi, half. Okay. So chapter 5 of the Indian Contract Act talks about certain relations resembling those created by the contract itself. This part is on quasi-contracts. Even though the contract does not mention the term quasi-contract anywhere, the fundamental rationale behind the quasi-contract is a theory of unjust enrichment. So, this theory prevents one party from getting unjustly enriched at the expense of another. So, even without a contract, in the name of justice and equity, obligations can be made to arise. Okay. So, whether you like it or not, but once you accept a particular thing as your duty or as your obligation, when you enter into a contract, it is your duty. For example, A has accepted to deliver 10 truckloads of cotton to weave a cloth by the person B, party B, and the payment has been made by party B to party A to supply the cotton, 10 truckloads of cotton, and if he is not doing it, if he is not delivering the 10 truckloads of cotton, then the manufacturing unit has to shut down by B. So, there rises a quasi contract. Even if they have not mentioned it in their contract or not precisely written it down that A has to deliver, but he has the obligation to deliver what is accepted. If not, the legal right against A arises and B has all the right to take him to the court and sue him. So, section 69 creates a contract of guarantee in the absence of one. The contract of guarantee is a contract wherein one person, the guarantor, promises to the other, the principal debtor, that the former will pay the debt of the latter if needs arise. So, you would have heard about the bank sureties, the guarantees. So, where if one person is taking the loan, there is another person who is a surety, who is being put as a guarantor, where if one person fails, whoever taking the debt fails to repay the loan, then the second person who is been signing as a guarantor has the obligation to fulfill the debt accepted by the person taking loan. So, in case if the person taking loans, for example, A is taking loan and B is the guarantor and C is the bank. If A fails to pay the amount to bank, that is C, then B will be obligated or liable to pay the amount to B. That is called a guarantor or surety. But this section protects the rights of the guarantor in the absence of the contract of guarantee. If there is no contract of guarantee made, then it protects the rights of the guarantor. He is not made liable to pay the debts. Okay. So, if a person A is in debt to B and another person C pays B on behalf of A, then C will be entitled to be reimbursed even when A and C had not agreed in advance that C would pay off A's debt. So, what happens here? There are three parties involved. When A is in debt to B, A is supposed to give money to B and C pays the debt to B, but still C can claim that money from A even though it is not written anywhere as a contract, because C has paid the debt on behalf of A and A is supposed to repay that debt to C. Types of contracts on the basis of the validity of the contract. So, what is the validity of the contract? So, it is the time frame. So, validity amounts to the time frame of the contract. Too often problems arise with contracts and the courts must judge whether they are valid or not in the first place. So, based on developed jurisprudence and the laws, contracts can be valid and even invalid. They can also be void, they can be voidable, or they can be void ab initio. Okay. So, what are valid contracts? Section 10 provides for certain essentials that are considered under as the valid contracts. Okay. There must be free consent between the parties involved. As I already mentioned in my previous video, that parties must give free consent. They must enter into the contract with free will. No one should have forced them. Okay, no one should have forced them to get into the contract. And the parties must be competent to the contract. No one can enter into a contract with a person of unsound mind or a lunatic. Okay. The consideration, the object of the contract must be lawful. The consideration is the money or anything that is in kind or in money it should be lawful, it should not be unlawful, okay? So the contract must not be declared void under the law, like killing someone or transporting contraband. All of these things are not approved by the law, and it should not be declared by the law, it should be valid, okay? So that is called that is one of the major important essentials of a valid contract. So these essentials, when present, make a valid contract. Other than these essentials, certain other things also need to be fulfilled for the contract to be recognized by the courts. Firstly, there must be a meeting of minds, which we already know. For example, suppose a person sees a clock belonging to B and wants to buy it. The clock is actually metal, but because of its design, it seems wooden. It looks like wooden, it has a wooden finish, but it is a metal clock. A, believing it is a wooden clock, offers to buy it and B agrees. In this situation, what happens? B knows that it is a metal clock and he believes he is selling the same to A. But A believes that he is buying a wooden clock because of the appearance of the clock. In the very object itself, in the very outset itself, there is no meeting of minds, because A thinks he is selling something else, he is buying something else, and B thinks he is selling something else, but there is no meeting of mind. A thinks he is buying a wooden clock, but B thinks he is selling a steel clock. So there is no meeting of minds. That is why this cannot be considered as a valid contract. A valid contract gets formed only when there is an intent to create legal relationship. More than anything, you need to have the intention to clear or to create a legal relationship with the other party. Otherwise, it remains simply an agreement and cannot be enforced by law. Further, the performance of a valid contract should be possible. So, a contract for reviving a dead person is not a valid contract, obviously. So, next is the void contracts. Section 2J says that a contract that ceases to be enforceable by law is void from the moment it becomes unenforceable. The term void in law means not legally binding or invalid contract. Okay. So a contract becomes void when it is unable to be fulfilled. When the conditions of the contract are unable to be fulfilled by the other party, then that particular contract becomes void according to the section 10 of the Indian Contract Act. Thus, when parties are incompetent to form a contract, like minors or people of unsound mind, then the contract automatically becomes void. You cannot get into a contract with minors, unsound mind people. Okay. So, further, the impossibility of performance also makes contracts void. So the impossibility, for example, killing a person, it is impossible. You cannot do that for as soon as you get into a contract. Or bringing a person who is dead back to life, is that possible? It is not. If you are entering a contract to bring a person back to life who is dead, it is impossible. So that is the void contract. In the outset itself, it is impossible to fulfill the rules and conditions. That's what makes the contract void. Next is the voidable contracts. Such contracts which can be made void on one of the will of the parties. See, if there are two parties or three parties to the agreement, let us say 2 or 3 parties. A and B are in a contract. And if either of them feels, either A feels or B feels, if either of them feels that this contract cannot be fulfilled, or if he feels that this contract should not be in existence, then when he chooses to do so, he can make that particular contract void. In these scenarios, generally, consent is not free and it is obtained under coercion, which is mentioned under Section 15. and undue influence section 16, fraud section 17, and misrepresentation section 18. So what happens? Two parties get into a contract. A poses himself as a big industrialist and asks B to supply 10 truckloads of teakwood to manufacture furnitures. B gets to know that A is not a industrialist, he is not a business person, he is a fraud trying to gain advantage of B's innocence. The very moment B can go and make the contract voidable, because when either of the parties, either A or B, decides to claim the contract voidable because of various reasons. What are the reasons? It can be coercion, undue influence, fraud, or misrepresentation. When any of these elements is used while entering into the contract, or while signing the contract or getting into a contract, then the other party can easily claim that contract as voidable contract. Here the party has defrauded or unduly influenced the other party. Therefore, it makes the contract void. Okay. Next is void ab initio contracts. They are special type of void contracts. That means void from the very beginning itself. Void ab initio means it's a Latin word which says void from the very beginning itself, even from the inception of the contract, even from the inception of the agreement coming into existence, it is being claimed void. In essence, void ab initio contracts are those contracts that never existed from the moment of their inception or the very first moment. The most common example of void ab initio contract is one made by the minor. If a person gets into a contract or signs a contract with a minor person who is less than the age of 18 years, then that is considered as a void ab initio contract, because you're, first of all, according to law, you're not supposed to enter into a contract with a minor person because he is not in the mental maturity to handle the terms and conditions of a contract, and therefore he is not allowed to enter into a contract with a minor. And the best example is the Mohri Bibi versus Damodar Ghosh case, which is a very popular case where a contract had been entered with a minor person belonging to a royal family, and this lady, the grandmother of the person, fights the case out. I am not sure if it is the grandmother or the mother, but one of the person who was the guardian of the child fights the case, claiming that my son or my grandson is not in a condition to fulfill the contract because he is a minor. Okay. With this, we end this class, and if you are happy with the class and it was informative, please do subscribe and like. Thank you. For more videos, keep following us. Thank you.